Okay, thank you, Linda. So I'm going to go ahead and start with roll. Bashan, Hamilton,
Here.
McRae,
Here.
Olvera,
Here.
Darush.
Here.
Thank you. With the exception of Sharon, everybody else seems to be here.
Okay, let's go ahead and start off with public comment. I see some members of the public. Okay, Helen Bellamy, and I'm going to put the timer on 2 minutes for your comment. Go ahead, Helen.
Hello, hi, can you hear me?
Yes.
Thank you. I was on the call last week, and my name is Helen Bellamy. I got an opportunity to talk before you before. I am a legal document assistant, but more importantly, I am a member of the public and a citizen of the United States. I have a First Amendment right to actually access my court. This has been my position for the last 29 years. This committee has an opportunity to loosen the hold that the state bar has on the law. As a citizen, I should be able to go into court and assist other people with the law. I should be able to read the law. The fact that things are changing, this really is an opportunity for the bar to actually do something great. California is the leader, and we know that. We don't need other states to tell us what to do. California has to allow pro-pers and anyone else to help with the law. The unauthorized practice of law, we know, is a creation. It's a fiction. It is not true. It is something that is used to maintain the status quo. So I am urging, imploring this committee to not just, and I want to sound as though, hear the passion in my voice. Access is real. People need help. And there is an opportunity for the committee to move the ball further. This issue has been studied for 30 plus years. This is not new. I've been around that long. And I know that the same issues are being discussed that they were discussed 30 years ago. So please move the ball forward, allow people to have access to the law and assistance. Don't use, please, and I'm trying to see when Leah tell me the 2 minutes are up.
Your 2 minutes are up. You can wrap up. Thank you.
I will stop now. Thank you.
Thank you. Anyone else wish to make public comment? Okay, I don't see any other. Jamie Fosgate. Go ahead.
Hi, I just became aware of these meetings yesterday, actually, and had an opening in my calendar so that I could come aboard. My name is Jamie Fosgate. I am a family law attorney. I am in the Los Angeles area. I am a newer attorney. I went to law school at age 40 because I wanted to be able to help people going through a divorce have a good experience, not a bad experience. I focus my practice on helping people through mediation and collaborative work, limited scope document preparation. I do everything in my power to make it affordable for them. The reason I went to law school is so I could help people with the law. I could explain the law. I could interpret the law. I could apply the law to the facts of their particular situation, because you know what? Every marriage is different and every divorce is different. And I am all in favor of access to justice. That's why courthouses should be open to the public, which hopefully after the virus will be open again. There are law libraries people can go to. There are plenty of avenues for people to have access to the law. And there's plenty of assistance for people. And what I am in favor of is supporting our nonprofit groups who can help those of modest economic means to get the help they need. I don't think going online and trying to fill out divorce paperwork with the help of some computer AI is a good idea. There are tremendous consequences when it comes to custody of your children. It comes to dividing your retirement accounts. It comes to whether or not you have separate property claims, whether you have reimbursements. There's all kinds of pitfalls out there. And I think it's maybe not in people's best interest to think they can just go online, check a few boxes on a form, and they've done the right thing for themselves and their family for their divorce. So I am very concerned about the unauthorized practice of law, because I put a lot of time and effort and money and energy as a 40-year-old single mother to obtain my law degree so I could do this kind of work. Thank you.
Thank you. Any other public comment? All right. Seeing none, I think we'll proceed with the agenda for the meeting. So at our last meeting, you all had asked to hear from our newest working group member who has not actually been able to yet attend a full working group meeting, and that's Kimberly Kirschmeyer. Hopefully I did not mutilate.
I'm sorry, there's one more hand raised.
Okay, I'm sorry. Jeremy Klein, go ahead.
Thank you. My name is Jeremy Klein. I'm an attorney and certified specialist in the Los Angeles area. Previously was on the State Bar Board of Legal Specialization in the past, so I am familiar with some of the bar proceedings in the past. And I just wanted to offer a comment that I know the bar's focus is on protecting the public as well as access to justice. And it's important as part of that public protection function to avoid the unauthorized practice of law, that the people practicing law are thoroughly vetted by the state bar through the various admission procedures, and then later, if people become certified, through additional testing and peer review. And I would be concerned if people who didn't have that experience, who didn't have those qualifications, were allowed to advise the public, or if people were allowed to advise the public without adequate supervision. As the previous caller indicated, there are nonprofit groups. There are other means to assist the public without allowing people that are not lawyers, who don't have the appropriate level of training or expertise, to advise people on what can be very complex and sometimes life-changing issues. So I would urge the committee to proceed with caution and to protect the public and not have people that are not authorized to practice law. Thank you.
Thank you. Any other public comment? Okay, we'll move on. Kimberly Kirschmeyer, our newest working group member. We are thrilled to have her. Kimberly is the director of the State Department of Consumer Affairs. So it goes without saying that her day job is very relevant to the work of not just this subcommittee, but the entire working group. Before that, Kimberly ran the California Medical Board. So she's intimately familiar with the whole articulated structure in medicine that we're all familiar with. Specifically, I'm talking about nurse practitioners and physician assistants. And so at our last meeting, you all indicated an interest in speaking with her. We have her here. So I'm gonna open up the floor to Kimberly I don't know if she has any prepared things she'd like to say or just able to take questions from the group. We've sort of given her an overview of this discussion so far, and certainly the focus of our last meeting on this question of in-court representation. And after that sort of Q&A or dialogue session concludes, I'd like to bring us back around to where I think we are in terms of at least tentative decisions that the group has made as we think about our full working group meeting next week. So with that, Kimberly, welcome and thank you for coming.
Thank you so much for having me here. I can do a little bit of an opening, just kind of how it works with those two different types of professions. And then definitely, I think this is something that, you know, I'll answer the questions that you all have regarding the matter. So first of all, thank you for having me here, Leah, and I'm just looking forward to being on this work group. So with the issue at hand, you have, you know, individuals who may be doing a scope of another practicing licensee. So really kind of relevant, as you all know, to this for the Department of Consumer Affairs. It happens a lot within some of our units. But in this particular one, you have nurse practitioners and physician assistants who do similar functions in their scope of practice as a physician and surgeon, be it an osteopathic physician and surgeon or allopathic physician and surgeon, who are actually licensed by two different boards under the Department of Consumer Affairs. Just to give you a little bit of background about Department of Consumer Affairs, in case you don't know, is the Department of Consumer Affairs has actually 37 different boards and bureaus of different types of professions. They license about 3.5 to, it depends on what year, and about 3.8 sometimes licensees, and about 250 different license types. And so these are different license types that are within the boards that we actually regulate. And so you have nurse practitioners, they actually have their own board, even though they do perform some of the scope of what the physicians do. So they are under the Board of Registered Nursing. So they have to go through a license type. They have exams that they have to do. They have training that they have to do to meet the requirements. And then once they are licensed, then they can practice within that scope. Any action that would be taken against those licensees would be done by that Board of Registered Nursing, who is made up of both professionals, nursing professionals, as well as public members on that board. It's the same thing for the Physician Assistant Board. Again, physician assistants have specific training that they have to meet. They have licensure requirements that they have to meet. And then once they get that license, then they're under that Physician Assistant Board. And they would be having action taken by the Physician Assistant Board that actually is made up of physician assistant members as well as public members. One difference with the the Physician Assistants Board is they actually do have one member that is a member of the Medical Board of California. So they do have a physician member that sits on their board. In the past, that member was a voting member, but there was legislation that changed to make that individual an ex officio member. So while they are there and they provide support and they give information and background and help make decisions, they aren't an actual voting member. So that's a little bit different than what you see in some of the other boards where they do have overlap. There are some of our other boards that have overlap, and you would see different professions on those boards. So that's kind of just a very high, broad, 30,000 foot level over those entities. The one thing that happens also with the board of the Physician Assistant Board is their regulations. For a long time, their regulations would have to go through the medical board if it was a scope of practice regulation. So if they were looking to change anything within their scope, it would have to go through that board, and they would have to run that regulation change. So that's kind of again, high level, but I'm here to answer any questions about any training that they have, and any just, expertise from kind of living in that world of where you have individuals crossing over different scopes.
Muted, sorry, Steve and then Dana.
Okay. Kimberly, with the physician's assistants, do they have to work in a doctor's office? Same question for nurse practitioners, or can they have their own office independent of an actual physician?
So they both have physician supervision. Just wanted to let you know, kind of with all cards on the table, there is a bill going through for nurse practitioners, though, that they would not have to have physician supervision. But both of them right now have physician supervision. They do not have to be working in a doctor's office. They could have their own office where they're working, but they still have to have physician supervision even in that particular office that they have. The physician's assistant, last year, their board, they had legislation that passed. It wasn't by them, but it was the association that brought legislation to where that model of supervision has changed to some degree, and to where it's now, it used to be that they had to have a delegated services agreement. It's now called a practice agreement. And some of the particulars of how that supervision was put together, it changed more into the whole scope of what nurse practitioners have. They actually have standardized procedures or standardized protocols that are very specific as to what that individual can do. And the doctor is responsible for making sure that this person is competent to practice. They have to make sure that they feel comfortable with that individual doing the procedures, and they have all of that in a document, again, called the standardized protocol. And that practice agreement now with the physician assistants is very similar to that. They can also, each physician, they can supervise 4 nurse practitioners or 4 physician assistants. And they can, the individual now, though, under the practice agreement with the physician assistants, they can actually have more than one. It's not one-to-one. In the past, it used to be you had one physician and one physician assistant. Now a physician assistant could have more than one physician overseeing them. But again, it has to lay out in that practice agreement everything that those individuals, they would feel comfortable with that individual doing.
Does it contemplate them actually being in the same physical office, or is the supervision occurring either remotely or not on a 24/7 basis?
Yes, so they don't have to be there on site. It can be remote. They have to be available to them. So it could be a telephone call to that individual if they were running into trouble. It could be a Skype appointment. However, those individuals could, electronic, not Skype, but electronic means to communicate. But they do have to be available for that individual. It does not have to be on site for either of them.
But immediately available. In other words,
Right.
The expectation is if a PA or MP runs into an issue, within a minute or two, they're getting their supervisor on the phone to get direction.
Yeah, they would have to be available for them.
All right, thank you.
Can you talk a little bit more, and then we'll go to Dana, I'm sorry, but just about what that supervision looks like? I get that you've got to be available for a call, but is there any affirmative supervision happening?
Yeah, so it depends. Oh, sorry. Go ahead, Leah. Okay. So it depends on what's written in your standardized procedures or your practice agreement. But really that individual is overseeing those individuals and providing that supervision for them. It used to be with the physician assistants to where they had to review a certain number of their medical records. Now it was after the fact. But they had to review a certain number of their files. They had to make sure that they were looking at them and making sure that the individual is providing the appropriate care. Also, they'd have to co-sign on some of their prescribing. That all kind of changed now to where it kind of removed that specific requirement. And so now that practice agreement just really has to cover that avenue of supervision for them. To where they're, it's a higher level of supervision. It's not so going through every file. It has to be that doctor has to feel comfortable. The physician doesn't have to be present, but they have to be available. And they may require that physical presence of the physician if certain things are needed for that individual. It's really that oversee, and they accept responsibility for the services that are being provided by that PA. But it is a little bit different than what it used to be. And that's the way it's kind of been for nurse practitioners all along.
Okay. Dana.
Kimberly, thank you for joining us. I am wondering if you can talk about the history of the licensure of these two categories and what kind of opposition had to be overcome and where was the opposition coming from?
So Dana, I can't give you a lot of the history other than the fact that since I've been with the department and even before that with the medical board, these entities have always been a outside group. They used to be though, so the physician assistant board used to actually be within the board, the medical board, and then it branched out. It used to be a committee under the board. So a long time ago, like way back in history before, any of us were here, when it used to be the board, medical board was kind of like a large oversight board, and they had a lot of healing arts boards under them. And little by little, those all kind of branched out because they had their own individual committees within a board. And I'll do some research for our next group to get a little bit more information on that. But there was a different committee under that medical board, and they had all of the different types of healing arts, like psychologists, and all of them used to be a part of the medical board. But then little by little, like I said, they've all kind of branched out and became their own individual board through the process. So that's something that, kind of is interesting. So that I think they found that it was kind of duplicative because you had a committee that was under the medical board, but in a lot of instances, they were taking action on their own. So since I've been at the board, and that was for 20 years before I came here, they had always been their own individual board or their own individual committee where they were taking action. It's one thing just to throw out for the physician assistant board, and that's changing a little bit now, but for that board, when they were a committee and even now as a board, the medical board did their disciplinary actions. So they used the same staff, they used the same investigators to take disciplinary action, but the final vote would go to the individual board under the physician assistant members.
So I think, Dana, I'm not sure if you were asking more about the history of the development of a nurse practitioner and a physician's assistant. I think that's what Dana was referring to, Kim. And then in terms of opposition, even now, like you mentioned, these legislative changes that are going to go into effect in January, my understanding is there is some tension between all these different groups in terms of how much latitude and independence these various folks have. So can you talk about that? Yeah,
I definitely can, because it is definitely, I missed that part of your question, Dana, sorry about that. That has always been, so like I said, since their background and how they became a licensee, that was again before I came on to the medical board. But for them, there's always been opposition on any types of changes or any types of scope creep. Especially the dynamic between like physicians and physician assistants or nurse practitioners and any type of expansion in those. It's usually something that from my time with the medical board, usually the medical board would oppose any type of expansion, with the exception of if they made sure that the individuals, because they were always looking at it from that consumer protection element, to make sure that they had the appropriate training to do the function and that they would be overseen appropriately. So that was kind of one thing that the medical board always looked at when anytime there was any type of change in the scope of practice of those two. But there's always kind of been, a little bit of push and pull between those entities as to what they could and could not do. But I don't have the history of how when they first started as a physician assistant or nurse practitioner, but that's something I can definitely look into and get back to you on.
And my understanding, Kim, was that was sort of legislatively driven, right? Different.
Oh, yeah.
Right.
Yes, definitely.
Healthcare services.
Yeah. Mm-hmm. Yeah, in fact, any change within any of them have all gone through the legislative process to where that was something that's kind of argued out in that field, not really outside of the legislative process.
Okay, Fariba, sorry. We can't hear you.
Okay, thank you. Really useful information. Thank you. So one of the questions I had, and it was answered about, is highly regulated and everything is by legislation. So, to change it, you have to go through a long drawn out process. Are there also some local rules, sort of, that some regulations that are set by the boards, driven from legislation?
Yes, so each board can develop their own regulations. So they go through a process, the normal process of public comment and going through with any comments that are received and making sure that the regulations then go through the Office of Administrative Law. But each different board can do their own regulations, and they do that on a very frequent basis.
The boundaries, though, in terms of what nurse practitioners and physician's assistants can do, set by statute. I mean, that cannot be changed by regulation.
Right, their scope of practice.
Okay. And the practice agreement, which seems like it's a very important document, it's set by statute, right? The requirements of its content, or is it by regulation?
No, so that is actually set by, it has to have a certain few elements, but for the most part, it's on a case-by-case basis. There's samples that each board put on their website for individuals to have, but for the most part, that is an individual document that is between the supervisor and the practitioner.
Okay, so am I understanding correctly that its existence is required by statute, but the details that are included is set by regulation?
Yes.
Okay.
Yeah.
No.
And again, it's a very high level, though, even with the scope of practice, just so everybody knows, it's a high level of, if you read the laws, it's a high level of what these individuals can do for their scope.
Okay. And one last question is about enforcement. So I'm trying to understand, and again, this could be just because I don't understand the profession too much in detail, but I'm assuming there's certain things that are off limit, right? There are certain procedures, complicated heart surgery. I'm just being really facetious here. So in terms of enforcement, it seems to me like because it's tough surgery requires a hospital room or some, special equipment and room and all that. So it seems like the enforcement is also as a result of the fact that a physician's assistants cannot do something on their own. They have to bring in other players, and that limits them, right? If there's a rogue physician assistant out there that wanted to do things that they're not allowed to do, perhaps because they wanted to help somebody do it inexpensively. It's like that kind of because they have to bring in other players. It's like that's an automatic sort of enforcement of the rules. Am I saying that right? Is that they can't? A physician's assistant can't just go perform surgery if it's the hospital won't allow them to do that, right?
Right. And a physician assistant particular, they can be a first and second. They can do minor surgeries with general, but the surgeries that are beyond a certain thing they cannot do. They'd have to be an assistant. So they'd be a first or second assist during surgery, but only like a physician can do that, or an osteopathic physician, allopathic or osteopathic physician.
Okay, thank you.
Steven.
I just wanted to get clarification, Kimberly. Did you say that the supervising physicians are responsible for the physician's assistant to the point where they have to accept responsibility for the services provided?
Yes, they are, the physician, again, accepts responsibility for those medical services that are provided by that PA.
So if there's a situation with malpractice, then the consumer who is alleging malpractice would be suing not just the PA, but also the doctor that supervises them, right?
Yeah, that's not really my expertise in the world of the plaintiff side of the civil case, but it would be something usually when an individual sues, they would do, most individuals involved, including them. And when we have complaints for, physician's assistants or nurse practitioners, you're always looking at, was there a problem with the supervision as well? So there, we could open a case both with the physician assistant board could open a case, as well as the medical board or the osteopathic medical board.
Okay. And are there specific liability insurance requirements for either or nurse practitioners or physician's assistants?
Yeah, no, and then again, that's not something that the board themselves, they don't deal with the malpractice insurance.
Who sets the requirements for the insurance?
I'm not even sure, Leah, because again, that's not anything within the realm of the Department of Consumer Affairs or the board.
That's so
I believe
interesting.
I have some knowledge of that from the work that I did with the malpractice insurance working group. So I don't think that there's a specific, there's very limited requirements in terms of even physicians having malpractice insurance. They're not by their license required to have malpractice insurance unless they are engaged in surgery in an outpatient setting. But by default, doctors all have malpractice insurance if they have any association with a hospital. The hospital requires them to have insurance. And so that's where most doctors do. And I don't know how that carries over into the nurse practitioners. But again, in terms of licensure, it's very similar to attorneys, where attorneys are not required to have malpractice insurance. The same is generally true for doctors.
Yeah, and PAs and NPs are the same. It's not any of the part of their licensure.
The changes that are going into effect in January for the physician's assistant, will you remind us what those are going to do?
Actually, it was last January, so they're already in effect. And what it changed it from really is it broadened, it changed the dynamic of their delegation of services agreement. So it went from a more specific document to one that was a little bit more general, and it's more of a collaborative team discussion on their charts, and it's what the individual believes as the supervisor that they need to review. And I can send you out a document that has some frequently asked questions, Leah, that you could get to the members also, just with the changes. But then it also changed that dynamic to where it's not a one-to-one delegation of services. It's a physician assistant could actually have a document that they have supervision by other physicians as well. It's not just the one individual, but they would have to agree that, this individual, all of them, they're competent to do this, and these are the services that they're going to allow them to do.
Okay. Do you characterize that as a loosening up of restrictions or increasing restrictions? I can't tell.
Yeah, I would say it's definitely a loosening. It's going to more what the nurse practitioner was for, because there's no requirement now that the individual review 10 files and, over 10 months, or that they review a certain percentage of their documents. It really changed that supervision requirement to where they don't have to do all of that hands-on all the time.
Okay. All right. Any other questions or comments for Kim? Okay, it looks like no. So Linda, could you put the little quick slides up just to help?
Yes, I'm going to find those.
Okay, you can go forward. So I wanted to bring us back to the original scope of what you all were tackling. And we put check marks next to the items that we've touched on in these discussions. Those are in the left column. In the right, we really haven't. We talked about bringing civil harassment in from general civil, but we haven't. So I just wanted to put that up there. Progress on the left, not so much progress on the right. And then if you could go forward, Linda. And then I wanted to start taking a look at where you all are in terms of included or excluded tasks. So we've got, this is basically, Linda? Okay. So this chart basically reflects, hopefully, our discussions, your discussions. It's draft, so things can move. I think, Linda, you did put this hopefully in the Dropbox so people have access to it.
I haven't put it in the Dropbox yet, but I will.
Okay, so this is where I think we are. Leaving it all to you to initiate the discussion. We have a meeting next week. Ideally, we would have recommendations for the working group. I have asked the team that's beginning to draft a memo of some kind to characterize it as a status update, because I'm not sure you're ready with recommendations, but open it up to all of you to see where you want to go with this.
Leah, can we go back to the slide that has the list of things we did not talk about? And can somebody talk about CPS investigations and why it's on here?
Yeah, this came from the Justice Gap study. It was one of the elements included in child in custody. It was differentiated in that study from termination of parental rights, like a dependency proceeding. And we sort of speculated that this was a CPS sort of call, not necessarily, or certainly not an open CPS. It may be a CPS investigation, but not a situation where a dependency petition has been filed, because that obviously would not be appropriate for us to consider, given that there is court-appointed counsel for those situations. So this is pre any dependency petition being filed. And I just posited, and I think, there was a little bit of discussion about how sometimes there are CPS calls in very difficult custody situations. And that may be why this came up under family law.
Thank you. I remember now. Thank you.
Okay.
I'm thinking it's dealing with, like, when they'll come out and they don't see a basis to assert jurisdiction, but they might have a case plan that they make the parents sign off on. Like, they're going to, if the child's being delinquent from school, they have to agree that the child's going to be at school on time, or if there's a medical
or a safety plan.
Yeah, exactly.
Okay.
So I'm struggling with that one. It's such a narrow band of area in terms of, usually if CPS goes out and they're going to do something more, my read is 80 to 90% of the time they're going to take jurisdiction rather than rely on a safety plan. Does anybody have a different experience?
Yeah, well, in Santa Cruz, we keep those statistics, and it's more like 60% ends up, being put to a judge to make that decision. So this would just be somebody being allowed to speak for somebody who's had a CPS call and a social worker is coming out.
Yeah.
Okay, that's helpful. Thank you.
And that's my understanding too, that is sort of facilitating this conversation with a social worker, and just hearing stories from parents who come to our office and tell us that the social workers can be quite different in their mannerisms, and some people feel that they can't properly express themselves. And so my assumption is that that's what this is all about, is to provide that sort of in between where the paraprofessional is emotionally removed and is able to, speak with more on an emotional, without emotion, sort of, and try to kind of express the parent's position to the social worker and what's happening. In our county, so their social workers are told to cut down the number of cases that they refer to juvenile dependency because of funding issues. So a lot of these parents end up in family court for emergency screenings. And I think that there is a place for that with I'm not sure if it's legal representation though. So I'm not sure why it's on this list.
Because a lot of them won't, like if it doesn't happen very often for me, but if I've had that situation where a client's been contacted by CWS or CPS, they really don't want even the lawyers involved. Like if I try to insert myself into the interview, they take umbrage at that, and I don't know, they limit our ability to help our clients in that situation, has been my experience.
Maybe it's just being aware of what are the parents' rights, and in what situations they can refuse to answer or ask for a lawyer or things like that. I'm not.
The other thing I was thinking, remember the change, was it 3 years ago for EBA, where you can now get copies, they're sanitized copies, but get copies of the records, and parents needing to know that, knowing how to fill out the form.
Yeah.
Look, that would be included in that.
Mm-hmm.
Does everybody know what I'm talking about? So you as a parent have a right to get any reports or records pertaining to your child. They will redact out the names of third parties, reporting parties, but they're required to give you the record, and there's a specific form you have to fill out, and they have a time limit that they have to respond in. I think that would be a helpful service for a paraprofessional to be educated on and to inform a consumer about.
Mm-hmm.
I put those up on the right, just not to suggest that you needed to get through them today, but really just to say, there was an initial conversation about should we break this group up into further subcommittees because the scope was so large, and you decided not to do that. So I just wanted to say there are a whole number of items that you're gonna have to come back to, and I don't think, given the meeting is next week, I don't see how we're going to get through all of them by next week.
I think we can get through this chart right here, Lee. Some of these aren't difficult. Like the guardianship for me is one of the biggest areas where I think, for me, I could slide that over to the left column easily.
I would agree with that, Steve. I think that there's a lot of room there for assistance from paraprofessionals, especially if the guardianship is uncontested. And even if it's slightly contested, there's a lot of room there, and it's highly form intensive. So again, there's a lot of room for help. I was one of the ones who advocated for keeping violence prevention orders in one group. I think because there's some traits that are shared. And again, I think there's a lot of room for professionals to assist here, especially on day of court, provide that support. If the person's self-represented, maybe be allowed to sit up at the bench and help them organize their arguments. Because a lot of times, especially applicants are traumatized, and their emotions are high, and they may forget a document or something they wanted to say. A support person under the DVPA right now can't do any of that. They can go up to the bench or to the tables, but they can't say anything or help in any way. So I think that there's a lot of room there. And I think we discussed it just a little bit, but we always run out of time. So I would still advocate that they're kept together. And I think they should be also moved to the left side.
Okay, domestic violence, elder abuse, and civil harassment.
And there is crossover between, of course, domestic violence, and there could be custody visitation, child support, spousal support involved in the case. But again, I kind of want to keep it within the violence prevention group.
Okay. And do you think, with respect to either guardianship or these three, that there's any additional work to be done around the authorized tasks the way that you've done that sort of deep dive in family law?
No, it's so form driven I'll talk about the guardianship. It is so form driven, and it is, most courts will do written recommendations or tentative opinions beforehand so that if there's any errors, a paraprofessional could help someone see that and fix it in advance of the hearing instead of it dragging on.
And the court does a lot of the work with guardianship because there's the probate investigator's office that gets activated as soon as a case is filed. However, I do think that these cases can get highly litigated, but only in the area of custody and visitation. Yeah. So unlike family law cases where you could have support and you could have property and all these other crossover issues, you will not have that in a guardianship case. So I forget what our discussion was regarding custody visitation litigation and how we felt about paraprofessionals advocating in court.
Yeah, let's see if we covered that.
I think that's where we get to it there. I think that's what I was trying to suggest, Liz. I think we can wrap up the second slide and include everything in there in the scope. And because really what we're doing is we're doing the deep dive on the next slide where we're saying what exactly can they do. And all of these areas, a paraprofessional being able to give legal advice would be, I think, very helpful, increase access to justice.
Okay.
So it's more of what are the actual tasks that we're going to do. All of these are legitimate areas.
Okay, you want to go to the next slide, Linda?
So we're going to deal with the elephant in the room now?
Sure. Whatever elephants you guys want to deal. Elephants.
Which elephant is that?
Whatever.
The in-court representation. We are so divergent based on what our backgrounds are and our experiences are as to this issue. I can't imagine us having a unified opinion on this issue. I think this is going to be, whether or not in-court representations, it's going to have to go to the committee at large. It's going to be, we had very few disputes when we were dealing with the wobbler areas, but Elizabeth and I had that experience with trust in the state. I think there's going to be at least myself from this subcommittee advocating against any in-court representation in any circumstance. And I think there'll be probably a majority are going to disagree with me.
Can we at least lay out the different options? Because I think there's one scenario where it's absolutely nothing in court, and then versus full scope representation, they can do everything a lawyer can do. But there are some other gradients along that trajectory that some of you have talked about. Could we flesh some of those out, just so as we as a staff team are working to write a memo for the full working group, we can articulate sort of the different options that are discussed.
My opposition is pretty resolute in terms of any in-court work. And I think some of the things that we just heard from Kimberly kind of support where I'm going with this and why that's going to also still be my ultimate opinion. I cannot imagine a scenario where there is an attorney that's going to be on call or a judicial officer that's going to allow a hearing in progress to be interrupted so that a paraprofessional can get a hold of their supervising attorney to address an issue that's come up in the hearing. I think that what we heard last week anecdotally, we've got one state, Utah, that only has 4 paraprofessionals, so we don't have any data about how they were just starting the process, I think, of allowing them to go into court. And one of the comments was that was only in limited jurisdiction cases. So, it wasn't even limited jurisdiction, it was small claims. So I know where my position is, and then the rest of the group, I think I don't know where everybody else lies, but I know that I'm in the minority, can define what the scope is, but I'm not comfortable with any proposal that supports in-court work as part of the initial rollout. And again, we don't have, even in Arizona, where they were taking, who was the gentleman that was speaking from Arizona, Leah?
He's the head of the State Administrative Office of the Courts.
Okay. So, he was definitely gung-ho. and was promoting it. But again, they're just about to roll the program out. And so that's where I think it's such a big step to take. And I think that there's so much work that can be done that will lighten the load on the justice system and enhance access to justice by allowing us to switch from this, you can't give legal advice, to now they can give legal advice. That's where at least I'm at. Anything that incorporates in-court representation, I'm not in favor of. And then I'll remove myself from the discussion about the parameters of what others think should be allowed.
May I go next?
Yes, please do.
Okay.
Just jump in and don't bother raising your hand.
So,
Oh, I'm sorry, Dana. If Dana did have her hand raised, she was
sure, no problem.
So let's go with Dana, and then let's forego raising hands if you guys don't mind. Okay.
I'm just wondering, Leah or Linda, can you tell us if any of the subgroups are recommending any level of in-court representation? Because I think it would be odd for our group to say there is no avenue for that if others are finding an avenue.
Yes. In fact, so for general civil, there's recommendations around debt collection issues. This was from the last iteration. There are recommendations for certain types of wage and hour cases. So yes, it's just coming to the top of my head. It's not an absolute ban for the entirety of the program. It's very subject matter specific as far as I can see right now. Fariba?
Okay. I am actually not quite opposed to Steve's position. I'm not opposed to having paraprofessional have some role in courts inside the courtroom. However, I think there has to be a bright line rule for ease of enforceability. The question I asked earlier from our presenter was to kind of show that, you know, for a physician's assistant, the enforcement comes with the territory, right? They kind of can't do things they're not allowed to do because they will need third-party players who will not allow them to do it. And we need to make it easier for our court and the public and basically everyone to kind of know what a paraprofessional in this scheme can and cannot do. And to me, I also oppose representation in court in terms of at an equal level of an attorney, regardless of the issue. I think that a couple of our public commentators were right on point in that we can find other ways to provide access, but not this way. I think there is a reason there is, you know, legal education and law school, and the same as there is, you know, medical school versus the physician assistant school. Okay, there's two different things. And I totally think Steve's point is valid that, you know, no judge is going to wait for how are we going to even regulate that? That, you know what, they're going to, okay, hold on, judge, I'm going to call my supervisor. I mean, no, you have to be able to think on your feet to be a good litigator. And hence why I don't litigate, because I don't think quick on my feet. I do this really good. So, you know, I just think that there is a place, and that place is to sit at the table and provide assistance to the self-represented to represent themselves. I think there's a lot of value in that, to help them organize themselves, okay, organize their documents, to just be that emotional support there and prepare them before court. You know, what is the courtroom going to look like? Who are the players? Where does everybody sit? And maybe even pass notes or be able to kind of whisper something. I'm not sure. I mean, we can work out those details. I just think there's a hybrid that's possible here, and to allow them a little bit more of a role. People are going to represent themselves. You're not going to get rid of self-represented litigants, even if you license paraprofessionals to do everything under the sun that attorneys can do. I think people are going to choose not to spend money even on paraprofessionals, okay? So there's got to be this hybrid that we create to provide options to the public, that you don't have to hire an attorney for everything, and you don't have to be completely on your own. And here are a couple of different hybrids, right? You can have someone just prepare your forms, you can do limited scope representation, and you can have this paraprofessional in this role sitting with you right up there. And I think that will provide a really good and valuable service without kind of allowing them to act as a lawyer and provide full representation.
So Kim, are you still on the phone? Are you still here? Okay.
Yes, I'm still here.
I wanted to ask you, Reba, you mentioned they won't, physicians assistants and nurse practitioners won't be able to do things they're not allowed to do because there'd be a third party verifier. I just want to see if that's entirely accurate, because you didn't really discuss, Kim, the supervision structure for nurse practitioners, but they're not in the room with the physician's assistant or the nurse practitioner with their patient. Is every unauthorized activity something that a third party would find out about and be able to enforce?
And the third party being whom?
Well, I think that I know that there's certain types of surgeries physician assistants can't do. So presumably
Right.
it couldn't just operate on you in their office without anybody knowing about it. Like they'd have to go to a hospital and people would know they weren't authorized to do something. But that's the kind of third party.
Yeah, they get, privileges at hospitals to do things, so the hospital would know what they can and cannot do. But I mean, there's nothing, obviously individuals can do things against the law at any time. So if they were in their office, they could do something potentially that they're not allowed, or they don't have the training that's not part of their standardized procedures. Their protocols, they could do that. And then, it'd be up to the patient to make a complaint. But the patient wouldn't necessarily, know that at that time.
Yeah, that's what I was thinking. I just want us to be, if we're going to cite things from the medical world, I just want it to be accurate, because my impression is there's not always a third party verifier of what's allowed and what's not allowed.
And I was comparing the courtroom as the hospital. If the paralegal or the paraprofessional in their office wants to give legal advice on quadro or property issues that they have absolutely no knowledge of, yeah, absolutely, there's nobody there. But if they come to court, I'm kind of comparing that going to a hospital, okay? And are our judges going to kind of want to enforce those rules? I tell you, unless it's a bright line rule, that is, you sit at the table and you don't talk and you don't represent, our judges probably are just too busy, especially right now when we've got court closures and everything. So, and this is nothing immediate, but I'm just saying that's what I'm comparing it to.
And I probably should clarify. When I say my opposition to appearances, I'm meaning they're making an appearance on the record and speaking for a party in court. I'm not opposed to the at counsel table assistance in terms of organizing documents, because they're not appearing there and they're just acting as a trial assistant or a hearing assistant. But in terms of actually uttering words that make their way onto a record where they're advocating for a client, that's what I'm constituting as an appearance.
Okay. Dana, do you have any thoughts on this topic, or sort of the options that we might include in the memo?
Well, I think that's progress. What we just heard from Stephen is progress for sure. And I just want to say, I don't think anybody on this subgroup is advocating that a licensed paraprofessional can do everything an attorney can do. I haven't heard anybody suggest that. I am wondering if there's any room as we begin for a licensed paraprofessional to truly represent somebody. And just by way of an example, a dissolution of a marriage that has no children? Or are there monetary caps? Because one of the concerns that's been expressed is the level of risk that people would take if they hired a licensed paraprofessional as opposed to an attorney. I'm wondering, is there a place where the risk is very low, where we might recommend true representation and see how that goes?
I just think there's an enforcement issue. Who's going to determine is that risk level met?
Yeah, and I'm of the mind we've got no anecdotal information from other areas. We're talking about what we're proposing, both in terms of the scope of the areas, just from the other subgroups that I'm aware of and been participating in, is so far beyond what any other state has done in terms of subject matter and extent of services. I can't get around the idea of allowing someone who is not an attorney making appearances at court and making representation, even if we think it's uncontested, because you could have a situation where there could be a power differential, Dana, and so the partner who is the more controlling one uses their resources to bring in a paraprofessional who does the same things that an attorney would do, but does it cheaper and has the impact of minimizing and or exercising financial control over the weaker partner. And we're now creating a less expensive option. And someone who does not have, I believe, will have the same amount of ethical education and training that is required of an attorney. Doesn't mean there's not attorneys out there that pull that crap, but I'm just concerned. I don't think as our rollout that we should have non-attorneys making appearances in any type of cases.
I hear that, but in your power differential example, I wonder if the choice isn't a licensed paraprofessional or self-representation, because that's often the case, and it's very often women. I'm very, very curious about what Elizabeth might have to say.
So thank you, Dana, for the mic. I'm just trying to think about California, and the majority, and just 33% are of Hispanic descent, of modest means. And right now we have, they're going in there and they're using up valuable court resources, and that's great. They're getting some help. In the absence of having a paraprofessional, we're using a lot of court resources that could be diverted elsewhere if we allow the paraprofessional to assist in pro pers. The point of the program to give legal advice is so that we can do a lot of behind the scenes work, so we don't necessarily have to go to court. It's like doing stipulations, preparing the in pro pers for mediation. In terms of uncontested cases where there are no children, those are done usually as true defaults or defaults with marital settlement agreements attached. And so again, a lot of those cases don't even get to the court level. We have the summary dissolution where if you meet certain level of income, let's say $40,000, if you have assets less than $40,000 and debts less than a certain amount, then you can both just sign one document, the petitioner and the respondent, and then you get a judgment in 6 months. And after you do financial disclosure. So there's already things in place to help those, but where we, I would like the paraprofessional to sit at counsel's table to whisper in the other person's ear. We can prep the client as much as we can, but in reality, once you're at counsel's table and you have opposing counsel, has an attorney, and your mind goes completely blank. We can help, the persons organize their thoughts, come in with an outline, but it gets lost in the shuffle, it gets lost in translation. So I do believe that we should have someone at council's table and give them that. I don't know that we want to I don't want to file a notice of appearance. I don't want to, the paraprofessionals, most of them don't like to do that. They prefer to refer it out to an attorney. And so maybe we can find a middle ground where we can give them. And then just to clarify, a paralegal would not, if we were to move forward and allow in-court representation, I don't know that we would have to stop the whole proceeding just to call an attorney. I think what they're talking about here is talking about with no supervision and what are the parameters within that. Yeah.
And Dana, I was going to add something too. I'm saying what it has in the rollout. I still am of the opinion, particularly in family law, I would like to see us propose to start off with a pilot program. I am going to volunteer and suggest that we do the pilot program in northern Santa Barbara County and San Luis Obispo County, because it gives us a smaller demographic pool to look at to see how effective it is. I'm particularly interested about including northern Santa Barbara County. I'll show you why. Because I think, oh, can we change it to participants able to share screen, please?
Yes.
Okay. So this is why I'm really interested in including. So this is Santa Barbara's demographic makeup. North County is basically Santa Maria. And that is an area that there are 3 different judicial officers, and I'm in those courts on a fairly regular basis. And it is such a strong Latino population in the Santa Maria area. Look at 61%, and they are not getting help. And that's an area where they have in the past been taken advantage of by the notarios dealing with immigration issues. My feeling is if we try this in an area where we can specifically address segments of the population that have not been getting adequate representation, and in the trial program, if it becomes apparent that we're really doing a disservice to the judge by not letting the paraprofessional participate in the hearing, then that's going to change my mind. But I'd rather test it and see how the program goes without them making appearances. And then after the trial program, we can say, you know what, this is a mistake not to include them. But to include them at the outset causes the concerns I have to make me take such a strong line at the beginning. Thank you for letting me show the screen. But okay. So that's whenever I talk about this is what I'm in. We've got a law school in San Luis Obispo. I've got easy populations and a limited number of judicial officers that I have to track in the 2 counties. So usually, you want to do a test program in a big area, but I think it makes it more difficult to track the results. So that's actually going to be one of my suggestions, Dana.
Okay, so I think what I'm hearing is, there doesn't need to be one recommendation or one option presented to the full working group. I think, Steve, your idea about pilots is applicable perhaps not just to family law, but the rollout for the paraprofessional program generally. But certainly we can have included in the memo that goes forward to the group next week, the full working group, an option is no in-court representation at this time, but that it sounds like you, Stephen, and you, Fariba, it sounds like you're on the same page, which is no in-court representation can sit next to a self-represented litigant and provide them with some guidance, but not speak in court. That's what I'm hearing. And then, Steve, you've got this additional recommendation and this should only be rolled out as a pilot in 2 parts of 2 counties. What I want to try to flesh out is other options so that we fully laid out. So Dana, I hear you saying there could be actual representation in court limited by certain parameters, either case complexity, if there are no minor children. So maybe we can flesh that out. And then Elizabeth, I think you were saying something similar to Stephen and Fariba, I wasn't quite getting it, because in one hand you were saying the paraprofessional would not necessarily want to represent the client, but on another hand, you're saying once you're in there in the courtroom, it's not that easy for you to speak for yourself because you get kind of, you know, these are emotional cases. So I have to come back to you, but Dana, maybe we could flesh out your option so that we have this list of options to present to the group next week.
Well, one just very basic example would be guardianship. If there's an uncontested guardianship, that there's a reason that it has to go before a judicial office. The forms are all simple and they speak for themselves. I just can't think of a reason why, especially if it's often grandparents, they don't want to be in court because they don't want to run the risk of running into, even if it's uncontested, their child who is incapable of parenting. Why couldn't a licensed paraprofessional simply represent in that instance? And I think that we could come up with other examples like that.
I just want to make sure I'm understanding you correctly, Dana. Are you thinking that the paraprofessional's appearance would excuse the party's appearance?
Not necessarily, but
in the example you gave. But I thought I heard you say, you know, it would allow the grandparents not to show up, not to run into their children.
If it's something as simple as an uncontested guardianship.
No, parties, as far as I know, in our court, maybe in other counties it's different, but in our court, parties have to appear. Of course, we're in the middle of a pandemic and the court called excuse the current circumstances. Right. But no, you have to appear. And usually in uncontested cases, like Elizabeth mentioned a few of them, there's really usually no need for representation. I think we're not talking about uncontested easy cases. We are talking about contested cases. And if anybody disagrees, please say something. But I'm thinking we're not talking about uncontested cases. I'm just again gonna say that Elizabeth mentioned uncontested cases normally are done on paper. Guardianship uncontested cases cannot be done just on paper, but the appearance is literally, I used to do that when I was in private practice, literally like 4 minutes long, because the probate investigator is done, the parents don't disagree, and the judge pretty much just goes through a little bit of a script, done.
So I think for the first program, I could say that the person has to be there, right? The client needs to be there when the paraprofessional is speaking, I think as the first one. But I can see where in domestic violence, right? People have been silenced, the victims have been silenced, and they don't want to speak. It has been very hard for them to be in a position to even come to the courthouse, even to put this information forward in front of the judge. And so I can see where a paraprofessional can be allowed to speak on behalf of the victim based on the information in the packet. Now, all of this has been submitted previously, so the court has information, the judge and opposing counsel. But I do think that the party should be there. But if the paraprofessional would be better able to present the information in an organized manner and not speaking for the client, but just talking about what the submissions say, I can see how that could work, and where that would be very necessary for domestic violence court hearings, because right now the people who go with them now are not allowed to address the court directly. Dana, was that more or less like something that you think could work?
I'm just trying to identify some basic, I mean, if we wanted to start somewhere with true representation, could it not be in an uncontested matter?
I just want to point out, when we went through very quickly guardianship, violence, I forgot, Fariba, the name we have for the category, I want to say family
violence prevention.
Violence prevention and the CPS investigations, very quick. And I asked the question, do we need to come back to these to look at authorized tasks? And you all said no. But I think that if in-court representation shows up in any of those areas, and you're not all on the same page about what kind of in-court representation should be allowed, I would suggest you do need to come back on those. And I think, Dana, my question was more about in the family law, not guardianship, not violence prevention, but in family law, you seem to be leaning towards at least providing an option that would have representation. So what kind of scenario? Because I think you guys are going to have to come back to guardianships and all of that personally. I'm not sure you're all on the same page there.
Can I interject here, just say, and I think Steve would agree with this, but let's see. I think the difficulty as an attorney I'm having here is the complicated legal arguments, especially if the other side has an experienced attorney who can reach into, you know, his or her toolbox of multiple years of experience and pull out these arguments and objections that the paraprofessional is not nearly trained enough to respond to, right? However, if you're talking about uncontested cases, okay, so that is, there's a hearing, the other party doesn't show up, right? The self-represented litigant shows up with a paraprofessional. If there's no appearance, then that triggers an exception in the rule that we're going to write and say the paraprofessional may present the case to the judge in an uncontested situation. So that way there's really no legal argument coming from the absent side. It's just a matter of presenting the case to the judge pursuant to the one party who's appearing, their position. So there's really no back and forth, no objections. What do you think about that? Is that something you were referring to, Dana?
I mean, obviously
that's a pilot to just start it.
That's giving ground. So obviously I'm going to be in favor of that. But I think it's interesting that the examples are always, there's a lawyer on one side and a paraprofessional on the other. But the real choice, and we know this from the Justice Gap study, is that there might be a lawyer on one side and a self-represented litigant on the other. And why is it not better to have a paraprofessional than to have nobody?
Yeah, and one example is, let's say in family law, court representation. So let's say a hearing for spousal support. So basically you're saying, well, you know, we need an attorney to make these arguments. Not really, it's all in the family code. You're just putting arguments that are in the family code. It's state law. You just read the law. I'm not trying to simplify how easy family code is. I'm just saying it can be taught. Now, honestly, the judges, some of them who are in these family courts have very little family law experience. They're coming from other places. So if anything, they rely on counsel to tell them what the law is, because that's not sometimes their expertise. So sometimes the paraprofessional or maybe the improper has gone to the law library, they pulled the statutes, they pulled the codes, so it can be trained. If, you know, in an argument for spousal support, yeah, there are issues that are gonna come up, like imputing income, like, you know, whether domestic violence was involved previously. So it's just about creating the training program to prepare the paraprofessional to make the right arguments in certain instances. Now, even this, let's say, for example, it's a request for order for a client, that information will be in front of opposing counsel prior to the hearing. So if they have any issues with it, it's not like you're going to be hearing it for the first time at the court hearing. So it's all monitored, it's all, and the judge has the ultimate decision. So, you know, it's almost monitored. That's all.
Okay, so I think I've got the Steve Fariba option. Dana, I guess what it sounds like there's some scenario that you would like to see where there could be representation in court, the parameters of which are to be determined. Something about complexity and something like that, but we'd have to further flesh that out.
I think that's fair, yeah.
Okay. Elizabeth, do you have an alternative, an additional option, or are you aligned with one of those two options?
I think So I think one of the things I'm hearing is that the paraprofessional can address the court and the paraprofessional cannot address the court. I think if asked to answer questions based on what's in the documentation, I think it should be okay to address the court. Yeah, and sit at council's table would be the alternative.
Okay, so I hear that as a little bit more restrictive than Dana, but not as restrictive as Steve or Fariba. Anyone correct me if I'm wrong. I'm just trying to get where we are. Okay, so
Can you tell me, Elizabeth, just one more time, sit at the table, and then when I missed that thing that made it different from what I said.
Being able to address the court, being able to answer questions, to explain a certain situation for the self-represented person.
And she raises an interesting point, because what's the paraprofessional going to do when the judge addresses them, right? They're not supposed to speak, but the judge can clearly see that they have the answer. Are they really going to make them? They're going to ask the paraprofessional. So I think that's very interesting.
That's why I'm a big proponent of the trial program, because that's what I want to sit in court and watch. I'm going to be, there's a reason I've obviously selected a geographic area that I can go to both of the courtrooms where I'm suggesting it. I mean, I've got this, my commitment goes beyond whenever we get done with our report in August to do what needs to be done to address the issue.
And, you know, we see that sometimes with the advocates, you know, the DV advocates person.
I think if they're constantly being asked by the judges, and I can see some courtrooms doing that a lot, and I can see others, and I don't know whether you write into the standard that they can respond to. I think we saw this in one of the proposals, that they can respond to questions from the court if asked.
Right.
I guess that's where I struggle with is I'm not dealing with an attorney on the other side, and they're making factual representations to the court. And as long as they stand to lose their license, like I do my license, if they lie to a judge, not a problem.
So the legislation, this pilot, by the way, I love pilots. It allows us to do a lot more. Could kind of provide for that, right? If a judge addresses the paraprofessional may answer.
And again, I'm dealing with more rural jurisdictions. I don't know if anybody's picked up on it. I'm the only one on the working group that's from a small county. Everybody else is from an urban area. And it just, being in this area, I think it would give us a good opportunity to see how different judicial officers reacted in a, as good of a sandbox as you could create. I don't know if that's a misuse of the sandbox term, but.
And the rest of it is really a matter of judicial education, just like with everything else.
Yeah.
I appreciate, Stephen, your offering of the San Luis Obispo area. That's great, but I believe that we should definitely not just go to that, maybe go where the diversity is. And maybe I don't want to just say, okay, that's where we're having the pilot program. I appreciate you offering it, but I just want to say off the bat, we need to keep open-minded about where these programs are going to be. But thank you.
That's why I'm suggesting you include Northern Santa Barbara County, which is 15 minutes from my office. Like I said, I go to that courtroom all the time. The demographics in that county, you're going to need to get another probably urban area to use to do the testing too. But that would give you a spectrum of some of our state demographics. But the Santa Maria is not a white community, so that's not. If the suggestion is we're doing it somewhere where it's not needed, that would not be the case. That was the reason I put the statistics up that I shared.
So as it's approaching 3:30, and I think, Elizabeth, there's going to be a lot of discussion at the working group around piloting, because it's the whole rollout of the program, not just necessarily family law. And I think there'll be plenty of opportunity to look at that as a concept overall. And then if that's the approach you all want to take, what are the areas that should be selected? So I think we are going to write up 3 different options with respect to in-court representation. If we could very quickly put up, Linda, the task list again, because I want to make sure, and we I don't know if it's in the Dropbox. We will make sure you get it as soon as this call concludes in 60 seconds to make sure that that list, as it currently has been drafted, reflects your views, again, other than this question mark for in-court representation. I had oral discovery as a question mark and written discovery as included. I thought that was my understanding of where you all had come, but I'd like to make sure that that's correct. And perhaps it's tied a little bit, Dana, if there is going to be full scope representation, in court representation, actual representation, oral discovery under that scenario might be an authorized task. I don't know. Like deposition.
I just think I think I had a concern about that in one of our meetings, that I think discovery is one of the areas that really takes skill, both written and oral. So for me, as long as there's a lot of, and it could be as important, if not more, than in-court representation, because it really sets up the case. So if those written discovery questions aren't written perfectly, near perfect, you know, your client is not going to get the information. And Steve is the litigator here, so I leave it up to him to say I'm wrong.
No, you're absolutely right. And the fact is, that's actually an area where paraprofessionals could outshine the attorneys, because there is, I would say, a lack of discovery experience among a lot of family law attorneys. The ones that came from civil litigation firms or civil litigation know what they're doing. But there's a lot that do not have. I go through so many cases where there's no depositions taken. There's not even a demand for exchange of expert witness information before trial. So I think that there's a lot of things where paraprofessionals, I don't know that I would make a differentiation, Leah, between oral discovery versus written discovery. They could advise them on discovery because they could still give a list of questions and be present during a deposition. That's one where they could really be present, and then during a break, give the follow-up questions to their clients, even if they weren't appearing on the record.
Okay, we'll make that change.
All right, we're good for today, right?
Yes, so Linda, we'll send it out if we haven't already. If any other changes to this chart, let us know, and we're going to hopefully quickly turn around a draft of a memo from all of you to the full working group for next week's meeting.
Do you need a grumpy old man picture for my section?
No, if you want to send a little write-up of your pilot idea to include, that would be very helpful.
Okay, you got it.
Okay, thank you so much, everyone.
Bye, everybody.
Thank you.
Have a great rest of your week.